Good morning, good afternoon, and good evening. We, the Institute of Chartered Shipbrokers East India, have partnered with the Nautical Institute India Southwest Branch to bring to you this webinar on Suez Canal blockage and impact on international trade. May I remind the audience that the matter is sub judice and this webinar is only for an educative purpose. I would now like to introduce the chairman of both the organizations that lead from the front. Chairman of the ICS East India branch, Mr. Ravi Tittee, FICS, is Director Shakesheff Logistics and All Trans Lines Pte. Limited, Singapore. He has extensive experience in shipping, transport, chartering, and logistics sectors spanning 31 years, and he has been in the ICS Executive Committee for the last 10 years. Chairman of the Nautical Institute India Southwest Branch, Captain Tom Joseph, is a commissioned officer in the Indian Navy, specialized in hydrographic survey, and was formerly trained in computers from the School of Computer Science, JNU. He switched to dynamically positioned dive support vessels after premature retirement in 1999 and retired from regular sailing in 2015. I now request Chairman Ravi Tittee of ICS East India to welcome the gathering.
Thank you, Aarti, for your nice opening remarks on the program and also introducing me. Before I proceed, let me just tell you a few lines about Aarti. Aarti is an honors graduate in law, postgraduate in maritime law, University of Southampton. At present, she is with ABS Marine Services as a manager, legal and HR. Aarti is currently also a national treasurer of Vista India, and of course, a very vibrant committee member of ICS East India branch. Of course, a very few know that she's a very graceful classical Indian dancer too. Mr. Kevin, President of Institute of Chartered Shipbrokers, Captain Tom Joseph, Chairman, Nautical Institute's Southwest Branch, Captain Menezes, Captain Goveas, Advocate Bharucha, Advocate Karnan Thirupathy, Captain Joseph Alapet, my colleagues in the Executive Committee of ICS East India Branch, members of ICS East India Branch, members of ICS other branches worldwide, all the guests connected virtually, greetings and a very good afternoon to all of you. We have close to about 700 people, 760 registered so far, and hopefully all of them will be logging in soon. I do hope all of you are very safe and healthy. Tough times for people around the globe, and especially very challenging for people in the shipping and logistic industry. But on the flip side, and because of this pandemic that we were able to connect to all of you globally. Suez Canal blockage and the impact on international trade is the topic of discussion today. A major disaster in the Suez, and all of us are aware of the after effects of the same. A lot of discussions and talks have been going about in various forums in the international arena. We at ICS East India thought of this subject, and after some consultation with Nautical Institute, we went ahead with this seminar. We have brought in the best and the experienced speakers today, and I'm sure there will be many takeaways from this meeting today. The ICS, just for the benefit for all the audience, was established in 1911 and is the internationally recognized professional body devoted to promoting ethics and professionalism on the global basis in the various disciplines of commercial shipping by setting the required very, very high standards through its members who are qualified professionally of the international merits. Some of the aims of the ICS has been to build up a global base of duly qualified and competent members who seek membership only after passing the professional qualification exam and satisfying many evaluation criteria. ICS provide a very high-class education and training to cover the various facets of commercial shipping to those seeking a career in the shipping industry. ICS, they add value to the shipping industry by updating the latest knowledge and skills by conducting international level seminars and workshops on the relevant topics. This is one among them. We are close to about 5,000 members globally in about 25 branches worldwide. ICS East India has completed 25 glorious years. We have completed 25 years. We are fortunate to have with us still the founding members of this institute who are very active and keep guiding us day in and day out. ICS East India has emerged as one of the most and active vibrant branches of ICS globally, and ICS East India monitors ICS activities at Cochin, Delhi, Mangalore, Tuticorin, Visakhapatnam, and Kolkata. I'm sure Mr. Kevin will vouch for this. The Nautical Institute, on the other hand, is a non-governmental organization with consultative status at the IMO. Its aim is to provide professionalism, best practice, and safety throughout the maritime industry and to represent the interest of its members. The NI branches, like the ICS, are too vibrant, proactive. NI also organizes regular social events for awareness and development of the organization's. Our motto, our bond, our word, our bond, ensure that the members are of the highest degree of integrity, which is the need of the hour, especially when shipping has become very complex and a global business. With this, I would welcome our chief guest and the guest speakers and all the people who have connected on this session today. Thank you very much. And let's hear what our speakers have to say. Thank you very much.
Thank you, Chairman, for that warm welcome. We have amidst us 4 eminent speakers who will walk us through the various aspects of the Suez Canal incident, beginning with Captain Menezes, a master mariner and practicing marine consultant, expert witness and arbitrator, is the Honorary Secretary of the ICS East India Branch and immediate past chairman of the Nautical Institute, India Southwest Branch. He has carried out maritime arbitrations in India, for SCMA in Singapore, and for LMA in London. He will be followed by Captain Goveas, Director with Willis Towers Watson. He provides claims advocacy to the ship owner clients with respect to H&M and P&I policies. Prior to this, he served as master on gas tankers and was employed with a marine insurer and as a marine claims manager with another broker. Following him will be Advocate Bharucha, with over 20 years of experience, previously worked at Linklaters in London. He is nominated by the LCIA as an arbitrator in Indian-related disputes and has frequently given expert evidence in foreign arbitrations and litigations. He frequently contributes articles, participates in policy contribution, and is a regular speaker at various specialist conferences. At the end, we have Advocate Thirupathy, partner with the shipping and international trade team of the international law firm Kennedy's. Based in Singapore, he has been advising clients over the last 20 years on shipping and trade-related disputes across Asia. Qualified lawyer in England and Singapore, he is accredited by the Singapore Academy of Law as a senior accredited specialist in maritime law. I now hand over to Captain Menezes to begin the presentations.
Captain John, you have to unmute yourself and speak.
Thank you, Arati, for the kind introduction. May I have the PPT presentations, please? First of all, I would like to inform the honorable audience that whatever information is being imparted is available on public domain. And this particular part is set with an intention that the 3 speakers who follow will take up from the foundation that is being laid with this particular presentation. Friends, it is said that a picture speaks 1,000 words. And in the event that you have to have one look, here we have the Suez Canal with a convoy of 5 ships. On one hand, the canal is having goods being transited from the northern part of the canal to the southern part, carrying international goods. And this particular 210 broad waterway, though it separates Asia with Africa, you also have this particular bridge across Alcantara, the bridge of friendship. In fact, the Arabic word of Kantara is friendship, and this bridge has one pillar in Asia and the other pillar in Africa across 3 kilometers, and it is called the El Salam Peace Bridge, built in 2001. and the convoy of, and I'm taking you on this particular journey of the Suez Canal for your listening pleasure. Next slide, please. Well, Egypt, it is said, is the land of pharaohs Ramses, Tutankhamun, Nefertiti, and Cleopatra. And the Egyptians were the first country to dig a canal across its land with a view to activate world trade. Through the inscriptions found, the early dating of the canal is as way back as 2300 BC, Christian era, and the first canal was dug in the reign of Pharaoh Senusret III, linking Mediterranean Sea to the Red Sea across the River Nile and its branches as way back as 1847 before Christian era. Successively, this canal was opened for navigation by 6 other rulers who followed him. The efforts for the modern canal, credit goes to the French Emperor Napoleon Bonaparte, who on an expedition found the feasibility to have this landmass connected between the 2 rivers as way back as at 1799. But then they realized that the different sea level difference between Red Sea and Mediterranean was over 10 meters. And then there was research done. And in the year 1858, the Universal Company of Maritime Suez took this project on a 99-year lease, thanks to the engineer and diplomat Ferdinand de Lesseps, who opened up this particular canal for us on the 17th of November, 1869. And the beauty about this particular canal is under the Constantinople International Convention of 1888, this canal has been open for all vessels without discrimination during peace as well as in war. So this canal is open for all ships of all nationalities. And this canal was opened in the year 1856 on the 26th of, it was opened on 17th of November on 1856. And at that particular time, the dead weight was 5,000 metric tons for a ship's transit. In 1952, there was the Egyptian Revolution, and General Nasser then nationalized this canal on the 26th of July, 1956. We had the tripartite invasion of Egypt in 1957, 56 to 57. And then we had the Yom Kippur Wars, where the canal was closed for about 8 years from 1967 to 1975. That basically brings the historical background. Then we have the blockages. The blockages, the first 2 blockages I mentioned was when the nationalization of the canal took place. The second was during the Yom Kippur War. And then there have been some blockages off and on when the ships had transit problems. But however, by and large, this particular blockage of recent times of 6 days brought the enlightening call to all of us to not to take things for granted. And we know that any particular blockage in a particular canal brings about alternate routes. It brings about the demand for shipping. And when compared with the elasticity of the market, automatically the markets change. And in this recent blockage of 6 days, the tanker market had boom of 15% from the market rates. And if you have to take the role of a canal in maritime transport, a canal for a layman will be different, because he will be looking at a canal for transporting water across a passage, and then we will be having the water transported to his agricultural fields. But whereas for a mariner, a canal is a waterway, and it takes us from a destination of our choice, cutting across distances, saving time, voyage time, as well as fuels. So the beauty about Suez Canal is that it is a sea level canal, unlike Panama Canal, where actually, the sea canal, Suez Canal is cut through the water, but whereas the Panama Canal is stepped over by a lock system, where the canal is, the water is stepped up and stepped down as required. So the beauty about this particular Suez Canal is it is changing with the times. Now, if you have to notice the slides that will follow, if we had a 5,000 deadweight ship in 1856, we have 200,000 vessels passing the canal in a matter of 60, 70 years. Then 160, 70 years from the nationalization period. Well, this particular canal, ever since nationalization, has been under the Suez Canal Authority, which decides on the Suez Canal tonnage. It talks about the navigation rules. It talks about the VTMS systems. It looks after the maintenance of the canal. It also deputes pilotage services. And besides, the most important thing for the industry is the Suez Canal tolls. The Suez Canal tolls are fixed by the Suez Canal Authority. And Suez Canal Authority is also very sensitive also to the fuel prices, because they have to keep the canal tolls competitive, because in the event that the fuel prices are low, the owners and the operators may think of routing their ships on an economical passage across the Cape or vice versa. On the right-hand side is where you will find the the mouth of Suez to the Bitter Lakes. This is the southern stretch of the canal, where in fact we had the the incident on the 23rd of March. So next slide, please. If you have to take the trade angle, any particular trade, the shipping is the one which has lifeblood to the international economy, and the canal acts as the key factor in between routing the ships and cargo services in the best possible time. So what services this particular canal renders is that it allows ships of different types. You take the tankers, which consists of the products as well as the crude and oil, petroleum products. It contains bulk carriers of grain or coal. It has passenger ships. It has container ships, each container being that of a supermarket equivalent. It has general cargo ships, ro-ro carriers, as well as the other floating units which pass through the canal, which has got a geographical stretch from catering to Europe and America from the northern side, as well as Australia and Far East on the southern end of the canal. So this geographical stretch contributes to practically a shipping lane which has 12% of the global trade passing through this particular canal. As per the UNCTAD 2020 report, and as per the statistics of 2019, we had 11.08 billion metric tons of maritime trade, and annually that particular would come to 1.2 billion metric tons passing through this particular canal. So this particular canal actually is transiting almost 10,000 USD billion dollars worth of cargo per day. And it also plays a key role in the global supply chain integration, because many of the industries, whether it's raw materials or finished products, they would like to have their product just in time and at the right time, at the right place, with very little inventory loss. The other aspect of this international trade and connection is the impact on climatic change. Suez Canal helps us a lot in the reduction of decarbonization and the emissions of greenhouse gases. Because if you have to take that, I mentioned to you that the Suez Canal has also changed with the times. So with the economies of scale, we have had efficient ships, and also with efficient ships, the statistics show that the carbon emissions have had an adverse constraint, even though the fleet tonnage has increased over the years. Next slide, please. Well, how do you transit? Many of you, those who are listening, may have had the pleasure of crossing the Suez Canal during your sailing time, as well as those of you in the brokering and the shipowning would have done a lot of calculations. Well, you have two types of transits. One is the northbound transit, which starts from Suez Port Traffic around 4 o'clock in the morning. It's the northbound traffic, which starts around 4 in the morning. And you have the southbound traffic, which starts from Port Said around 0330 local time. And these particular transits, I mean, in the sense what you call, they move on either directions with pilots on board, and they make sure that the transits are what you call crossing each other somewhere at the Bitter Lake, and both of them exit. So this is how the system has been followed. But with the new Suez Canal, we have had the additional bypass of 72 kilometers, which the total length of 193 kilometers, this particular 72 will bring in a dual passage in the northern part of the canal above the Bitter Lakes. And then ever since from 2015, they're also planning to do the double laning in the southern part of the canal, so that the effective transit time will be reduced from 11 hours to 8 hours. The waiting periods will be reduced. I mean, at the moment, they accommodate 50 ships. They will be perhaps looking at having 97 ships transiting on a given day, either way, from 2023. So the Suez Canal Authority looks after all these particular operations. I mean, like in a deputation of the pilots, the tugs that are required, the vessel traffic management systems, the dredging. I mean, so everything is looked after by the Suez Canal Authority. Like I mentioned to you, that the Bitter Lakes is this particular passage where it's a very big lake, where vessels do, I mean, in the event have a problem, they take some time off to anchor, or like, you know, in the event that the convoys have not completed against each other, they have to buy time. So this is one particular place which is a large expanse of land, which helps in the smooth transiting of the canal. And if you have to take statistics, in the month of February 2021, we had almost 1,519 vessels passing this canal, of which 392 container vessels were transiting alone. And then that brings us a daily of 50 vessels and 14 container vessels per day. And if you have to take the importance, we have about 18,000 vessels transiting the canal a year. So you can imagine what busy shipping lane this is. And ultimately, come what may, in the Suez Canal, even though you have pilots, you have a convoy system, you have BTMS systems, the ultimate responsibility rests with the ship's master. So the ship captain is ultimately responsible. Next slide, please. So, friends, this is the northern part of the canal. I mean, in the sense what you call, like, you know, where you are seeing the port side. And then you have the bypass at Ismailia and Bala, and then the Great Bitter Lake. And then, like, you know, you're going into the southern part. And unfortunately, I'm not able to see because of the viewers. But so this is the new Suez Canal, which will be looking in terms of practically having 97 ships move through on one way from 2023. And perhaps accommodating the large bulk carriers, the containers up to 240,000 deadweight. Next, please. So if you have to take the cross section of the canal, this was how it was in the year 1956. You just had a ship of 5,000 deadweight, which went on to 150,000. And then, like, you have the present particular part of 200,000 deadweight. And very soon you will be having the 240,000 deadweight. And you are also getting the waterplane area and the depths which are to follow. I mean, very soon you'll be having 24 meters depth, which the canal will be using. And as per the pie chart, I mean, practically you will be having about 62% of the tanker fleet which can transit through the canal, 92% of the bulk carrier fleet, and 100% because of the container fleet which will be able to transit the canal. Next slide, please. So I'm just taking you to a little of understanding of the motor vessel Evergreen. I mean, like, it was built, the build was in 2018, and it was built at Imabari Shipbuilding Yard. The length and breadth is approximately 400 meters and 59 meters. The deadweight is close to 200,000 metric tons. Again, the GRT at 220, 940 metric tons. And then we also have the capacity. Why I'm mentioning about the capacity is like at 20,380 TEUs, you can just imagine the windage and the wind exposure that of an equivalent sail of a span of 400 meters with practically a 10 high container stack load on deck. Eventually, the flag of this particular Evergreen was the Panamanian, and the registry was also Panama. She was classified under the Classification Society of American Bureau of Shipping. The owners were Luster Maritime, and the beneficiary owners were Shoei Shinkasha in Japan. And next slide, please. And then we had the operator, who's Evergreen Marine from Taiwan, the technical managers from Bernard Chilton Management, Hong Kong. We had 25 crew members of Indian nationality, as well as the liability insurer management was from UK, the UK P&I Club. And comparatively, the goods were destined from Yanshan to Rotterdam. So the origin of the goods were more Chinese. And at the time of this particular transit, there were 18,300 TEUs on board, and the vessel was drawing a draft of approximately 15.6 meters. And the approximate value of these particular goods was estimated at around USD $3 billion. Next slide, please. Now, we take things for granted. And on the 23rd of March, we had an awakening call. This awakening call, I mean, like, was on the 23rd, after the vessel was stuck in the canal for 6 days. So we had two pilots who boarded. I mentioned to you that the normal time of departure is 0400. This vessel was fifth in the convoy, and the vessel had, there was the Costco Galaxy in front of it, as well as the Maersk Denver was behind it, and there were 14 other ships behind Maersk Denver. And it is stated that, like, there were winds of 25 to 45 gusts of 45 knots, but I mean, like, most of the newspaper publication says 30 to 40 knots. There was talk about sandstorm, which churned up the sands and affected the visibility. And then the grounding took place at 5:40 Universal Time Constant on the 23rd of March. And then we had salvage operations where Nippon and Smith Salvage worked very hard with a big Egyptian labor force, and almost about 30,000 cubic meters of sand was dredged by Boskalis. And the reflotation took place successfully, with no pollution, no injuries, and all going well, with the reflotation at 1300 UTC, 29th of March 2021. So effectively, she was aground for 6 days and about 7 hours and 40 minutes. Well, the present status of the vessel is that she's anchored at Bitter Lakes, but at the same time, there are lawsuits pending. I mean, that's between the Suez Canal Authority in the Ismailia Law Court, as well as from the owners. I mean, there is thing in London going on. So the points to ponder, which I'm laying the foundation for the three speakers to follow, is that we have different types of law, like Panamanian ship. We have what do you call Japanese ship owning interests, operations from Taiwan, origin of goods from China, and then what do you call the vessel is under Egyptian law at the moment in Egyptian waters, and then we have a gamut of laws. Understanding the conflict of laws. Second particular part, there is, as the moderator as well as the hostess declared, that this matter is under investigations. So we need to be patient and to learn whether it's a human or technical error. But at the same time, it's time for us to shed a tear of sympathy on the plight of the seafarers in this COVID pandemic. Just imagine that they are stuck on this particular vessel at the Great Bitter Lakes from the 29th of March. So kindly remember them, and wish them well. And hopefully these proceedings will come to a happy ending with the Ismailia Court of Appeal meeting again on the 20th of June. And with this, I would like to thank all the audience for giving me a patient hearing. Over to Ivor. Thank you.
Thank you, John. And Arti, may we have the presentation, please? Thank you, Arti. Hello, all. First of all, I'd like to thank the organizers for providing me with this opportunity to take part in the webinar as a panelist. Having said that, I will now take my pretty face off the screen so that you can concentrate on the presentation itself. This session intends to provide a quick overview of some prospective claims that may flow as a result of the ever given incident during a transit of the Suez Canal. The scene has already been set by Captain Menezes, so let's dive straight in. Next slide, please. So what is the status of the Suez Canal Authority claim? Following negotiations, the SCA has reduced its original claim of USD 916 million to USD 550 million. SCA has indicated that it will accept USD 200 million as a payment on account with a suitable guarantee for the rest. It is expected that the salvage award will fall to GA, but it is not presently clear as to what the SCA's claim constitutes. It probably includes salvage, damage to the canal, potential fine, and loss of revenue. Pending resolution of the SCA claim, the vessel remains detained and receivers of the cargo on board the vessel continue to face delays. Owners have claimed that the SCA was responsible for the grounding, backed by some supporting evidence. Owners have provisionally claimed USD 100,000 from the Suez Canal Authority for losses in relation to the arrest. The Suez Canal Authority have countered that the master remains in command of the vessel and the pilot's role is only as an advisor. SCA also maintains that the master is responsible to ensure that the speed limits set out in the canal navigation rules are adhered to. In addition to declaring GA, owners have also commenced limitation proceedings in London. The limitation fund is expected to be approximately 114 million. This may have the effect of all claims subject to limitation being brought under the fund and thus avoiding claims in many jurisdictions. England has adopted the 1996 protocol to the 1976 Fund Convention. This provides for the largest possible fund and should make it attractive for claimants to bring their claims under the fund. It also precludes the vessel from being arrested in other 1996 protocol jurisdictions. It does remain to be seen, though, if the SCA will bring its claims in the London limitation. But given the size of their claim, they may resist this.
But phoned up Rajiv or what?
No, what?
Next, there's some disturbance there. Next slide, please, Arti. Thank you. So let's move on to claims between owners and charterers. As we have already heard, the vessel is time chartered by Evergreen Marine Corporation. Evergreen will be looking at ways to avoid paying hire during the period of non-availability of the vessel to trade. Is the grounding an off-hire event? It depends on the agreed charter party terms. However, grounding is generally an off-hire event, and the vessel is expected to be off-hire for the period of the grounding. Is she off-hire then during the period of arrest or detention? Again, this would depend on the terms of the charter party. In broad terms, if a vessel is detained as a result of the condition of the vessel or trading history of the vessel, off-hire would result. The current detention, however, does not appear to be as a result of either. Having said that, it is possible that amendments to the off-hire clause could determine that the vessel is off-hire for the period of detention. If charterers are obliged to pay hire during the period of detention, they would have to show a breach of the charter party in order to avoid paying hire during the period of detention. They would have to show the ship to be unseaworthy. So what about cargo claims, which are expected to be indemnity claims between owners and charterers for damage and delay to the cargo? The terms of the bill of lading and contractual relationship with slot charterers will determine charterers' liability, if any, with respect to cargo claims. Charter parties often provide exceptions for errors in navigation, which may not offer protection for negligent navigation, where the AIG or AIG-VSB rules are applicable by incorporation of a clause paramount. Owners may rely on Article 4(2)(a) in defense of negligent navigation. Charterers may then, in turn, argue that the vessel was unseaworthy at the commencement of the voyage because the owners employed incompetent crew. Cargo claims may, under the terms of the charter party, be subject to the interclub agreement, which provides for a process of apportionment between charterers and owners. There are certain caveats as to the operation of the ICA, one being that the cargo should be carried on terms no less favorable than under the AIG or AIG-VSB rules, or when compulsorily applicable by operation of law to the contract of carriage, the Amberg rules, or any national law giving effect thereto. Next slide, please, Arti. So with respect to cargo on the Ever Given, cargo claims would fall under the framework of the bill of lading which is issued. On container ships, though, this may be complicated, as it is normal for carriage to be subject to container line terms rather than owner's bills. There are many different container line terms in existence with different law and jurisdiction and arbitration clauses applicable to the disputes, and it is normal for different container lines to have shipped cargo on the same vessel under vessel sharing agreement or a slot charter. So cargo is carried on the same ship, but under different terms and conditions without incorporation of the charter party above it. Focus in cases such as the Ever Given is on delay and delivery and not necessarily damage and loss. Assuming that English law applies, contract contracts of carriage provide for an implied obligation to proceed with reasonable dispatch. So, in principle, there could be a claim for delay. But liberty clauses in the BL may override this obligation. Often, carriage will be subject to an express clause stating that the carrier does not undertake to arrive at the port of discharge or port of delivery at any particular time or to meet any particular market or use, and the carrier shall not be liable for direct, indirect, or consequential loss or damage caused by delay. In case it is a claim for loss or damage, the provisions of the Hague-Visby rule or US COGSA or other applicable convention or law would apply. What about owners of the cargo on delayed ships? Do they have a claim? In the case of the Ever Given, the main cause to claim would be the consequences of delay. So let us quickly consider a couple of scenarios. What if you have perishable cargo on the delayed ship, which goes off due to the delay? English law provides for the duty of care to prevent physical damage. If the damage is due to natural process or inherent properties of the cargo, and not as a result of any physical damage caused to the ship on which the cargo is carried, this is a financial loss suffered as the cargo did not get to the market on time and unlikely to be claimable under English law. When it comes to non-perishable cargo, it is again pure economic loss and no recovery is expected under English law. So moving on to slot charters and vessel sharing agreements, these may not be governed by the same applicable law or dispute resolution clause as in the contract above them or the bill of lading below them. VSS are likely to contain detailed agreements as to allocation of responsibility for delays from various events. It is likely that each line is required to deal with its own claims in the first instance. Financial losses suffered by slot charterers may not necessarily be restricted to cargo indemnity claims being passed up the chain. For example, in addition, containers on the vessel may be owned by them, which would prevent them from fulfilling their obligations to have the containers available for other cargo at an agreed place and time. In the case of the Ever Given, it was not possible to transship the cargo and mitigate losses due to delay. Next slide, please. So let's consider the losses that may be suffered by vessels blocked by the Ever Given incident. It is possible that some owners may not have been able to deliver the vessel to a charterer prior to the cancelling date under the terms of a new fixture, or that a charterer may not be able to re-deliver the vessel to the owner by an agreed date. Most time charters will contain a clause requiring the owner to use due diligence to deliver the vessel by a cancelling date. In the case of vessels blocked by the Ever Given, it is difficult to see how owners would be in breach of their due diligence obligations. In case of a void charter, the vessel will be obliged to be available by a ready-to-load date and be required to proceed to the load port with all convenient speed. In the absence of a suitable exceptions clause, the obligation is absolute, so the owners will be in breach if they are prevented in embarking on the voyage in time to meet their charter party obligations as a result of an incident such as the Ever Given. What about late redelivery? A time charter may be exposed to damages. Although if the charter contains a last voyage clause, this may be avoided. However, having said that, it is likely that the most of the delayed vessels were midway through performance at the time of the disrupting event. In such cases, generally the risk lies where it falls. It is expected that time charterers will be obliged to continue pay hire during the period of delay or disruption. It is unlikely that they will be able to invoke any of the off-hire clauses. Most time charters will include an obligation on owner to proceed with utmost dispatch, which will depend on the circumstances. If the owner's intended route is blocked, the quickest route may involve a diversion. Under a time charter, as long as owners are being paid a hire, it may not matter to them very much as to what route they take. The consequences will be of more concern to an owner in the case of a voyage charter. Freight payable would be based on a planned route. What is an owner to do in case of blockage of the intended route? Stay or deviate? Can they recover the cost of waiting or the cost of deviation? In most cases, the likely answer is no. So broadly speaking, in case of a time charter, additional expenses fall to the charterer, and under a voyage charter, to the owner. It is unlikely that these financial losses can be claimed against the owners of the ever given. English law, for instance, does not allow for recovery of pure financial loss. Next, please, Ravi. So let's touch briefly on the insurance aspects. H&M, all and machinery cover, covers damage to the vessel caused by a covered peril, which would be the case here. In addition, owner's proportion of contribution to salvage and general average would be covered by hull and machinery underwriters. Indications are that damage to the vessel is relatively minor. Subject to the terms of entry, P&I would cover cargo claims and also claims for damage to the canal as a result of the incident. If cargo interests are successful in proving that no GA contribution is due from them as of a result of the vessel being unseaworthy, unrecoverable GA contribution that would have been due from cargo interests will be covered by P&I. Ship owner's liability, or SOL, policies cover claims that arise purely as a reason of owner's liability flowing from contractual agreements. For example, agreement to accept liability in excess of limitation or applicable conventions or law. Owner's losses due to the vessel being deprived of income as a consequence of damage to the vessel, which is recoverable under the hull and machinery policy, falls to loss of hire cover. Loss of hire, though, is not necessarily a cover that all ship owners do take. Cargo insurance. This covers loss or damage to cargo, including cargo's contribution to salvage and general average. However, standard contracts tend not to cover loss or damage resulting from delay. Extended cover, though, is available. One thing to note is that recoveries under all policies are subject to the applicable deductible. Next slide, please, Arati. And you'll be glad to know that that is the end of my presentation. Thanks very much for your attention. And you'll see me again towards the end when questions and answers take place. Thank you.
Arti, the next.
May we have Zarir Bharucha?
Thank you, Arti. Thank you. Ivor has covered most of what I was about to say, so I'm going to try and keep mine as short as possible. Now, I've been asked to speak about what are the problems and predicaments cargo receivers or cargo interests would face. It's a vast, vast canvas, and quite frankly, I am not that knowledgeable. There are people in the audience who are far more experienced than I am. But based on my limited understanding, let me share a few of my thoughts with you. The first and foremost discussion on any claim by cargo interest is to understand first what is the nature of the loss that is sought to be recovered. What are the damages that are sought to be claimed? Now, as Ivor touched upon this earlier, most of the cargo interests would be claiming for loss caused by delay or detention of the vessel, not physical damage to the cargo. The only category of claimants who would be claiming physical damage to the cargo would be owners of perishable cargo such as lemons and tofu, which I believe were carried on some of the containers. And once again, even there, it depends on whether the perishables perished because of their own inherent condition or due to the delay or detention. But I think it's important to note at the outset that under the system of English common law, which is applicable in Singapore, in India, generally speaking, a cargo claimant will not be entitled to recover for financial losses or what is called pure economic loss. They can only recover for physical damage. And that is a peculiarity of the law of torts, which we will, I don't have the time to explain, but it's something to be mindful of. I'm just throwing it out over there. The next question for cargo interest is to understand and analyze who are their contractual counterparts. Who would they first look to recover any of these losses? And that will turn on the bills of lading. Now, on these container lines, like the Ever Given, there are, as Ivor said, vessel sharing agreements between the various slot charterers. The bills of lading will not be issued by the head owner. The contractual carrier, i.e. the contract of carriage, will be with the relevant liner operator who has issued the bills. And this again introduces an additional layer of complexity because you have multiple liner slot charterers. So for example, you could be the receiver of or the holder, lawful holder of bills of lading issued by OOCL. Somebody else could be the holder of the bills of lading issued by MSC or CMA, CGM, or whoever, some other APL, another container line. Now, after identifying who your contractual counterpart is, the next thing you should be looking to is what are the terms of your contract of carriage. Now, the terms of your contract of carriage will be contained on the reverse of the bills of lading. Now, the reverse of the bills of lading provide, for a multitude of terms and conditions, but the ones most relevant for our discussion is delay and detention. So once again, typically the contractual carrier will exclude any liability for delay and detention. There will also be a carve out for general average in favor of the head owner. So basically what the operator will be saying is that in the event of general average, the general average will be declared by the head owner and then you would be bound by those terms. Now again, that's an additional layer. The head owner, and typically one would have to see what exactly the general average clauses give rise to. The other important clause that one must be mindful of is the law and jurisdiction clause. So it's not inconceivable that you have a OOCL or COSCO, who is a Chinese carrier, which may provide for its contract of carriage to be governed by Chinese law and Chinese jurisdiction. Now, this may be actually advantageous to the cargo interest to sue in China, particularly if under Chinese law they're able to claim for damages arising due to loss caused by delay or detention, which under English law and as I explained under the common law you would not. So once again, a complex overlay of different systems of law that one needs to be mindful of. But broadly speaking, the cargo owner is not in a happy position. The predicament he faces is that he doesn't have a contract of carriage with the head owner. So if at all he has to sue the head owner, it would be in tort or in bailment, and both of which preclude any recovery for delay, for loss caused due to delay or detention. He will also be liable for general average, because if the, as in this case, the head owner has declared general average. We'll come to that in a bit. But from a practical standpoint, whether given the rights or wrongs, without getting into the rights or wrongs of whether general average is validly declared, the head owner will be exercising a lien on the cargo and will not allow discharge of the cargo for transshipment, even if that were possible, without a GA bond being furnished. The other difficulty that the cargo interests would face would be that under the terms of their marine insurance cover, the Institute cargo clauses to be more precise, they would not be entitled to recover loss caused by delay or detention. And that is something perhaps the marine insurance industry would probably have to adjust to, and whether they'd be willing to come out with new policies as a result of this incident is something people in this audience would be able to debate afterwards. And finally, the cargo interests would be potentially liable to their contractual counterparts. So if they've sold the cargo, they've on-sold the cargo to buyers, depending on the terms of their sale contracts, they may be exposed to potentially to a claim for damages for failure to deliver the cargo in time. So clearly not a happy position for cargo interests at all. Now, turning to general average, and this is a fairly tricky and contentious issue, the head owners have declared general average. Now, as most of you know, general average is basically it's a sacrifice made in respect of a common peril or risk that both the cargo interests and the ship owner have been exposed to. So just pausing here for a moment, cargo interests may conceivably argue that, well, there is really no peril there's no real physical danger to the cargo. So why are we being asked to contribute? And clearly that is going to be a subject of much contention and debate between owners and cargo interests. And the second potential defense that cargo interests could take would be under the actionable fault defense, that is Rule D of the York-Antwerp rules, to say that basically, this incident was caused due to negligent navigation or unseaworthiness of the ship. Now, as Ivor just mentioned earlier, it's unlikely that the negligent navigation defense will succeed because typically the owner will be able to rely on the Hague Rules exception for negligent navigation. Whether the ship was unseaworthy, again, easy to say in theory, difficult to establish in practice. So the upshot of the general average position is complex and very fact specific, but these are just some of the larger issues that cargo interests should be mindful of if they're faced with a declaration of GA by the head owner. From a practical standpoint, the cargo really doesn't have much of a choice, because as I said earlier, even assuming that the owner's declaration is wrong, that is a matter for argument for argument later. It's basically pay now, argue later. So if you want your cargo, you basically have to execute a bond and then argue at leisure as to why you're not liable to contribute. So again, a difficult situation given that most of the cargo underwriters will not be willing to step up if the claims are for damage or detention. And again, there are complications even when posting the bond, because it depends who at the relevant time was the owner of the cargo, who had title to the cargo at the time the incident occurred. So that's an added layer of complexity that cargo interests face. The other problem that cargo owners will face will be this salvage. Now, here clearly there's been a salvage, an astronomical amount claimed by the Suez Canal Authority. But leaving that aside, the owners engaged Nippon and Smith for salvage services. And under Article 6 of the Salvage Convention, the master has the authority to bind even the cargo interests. So again, salvage security may have to, the cargo owners may be compelled to provide their share of salvage security and then subsequently agitate that and fight that out with the owners by saying, well, actually, you know, I shouldn't be asked to contribute to this because there was never really any physical danger to my cargo. And finally, the cargo interests could be exposed, as I mentioned, to potential liabilities under their sale contracts. Whether they'll be able to rely upon force majeure or frustration will depend upon the terms of their sales contracts, the terms and conditions of their sales contract. Once again, broadly speaking, force majeure will only apply if the cargo owner is able to establish that he was physically prevented from performing his contract. And it may be possible for him to say that due to the detention by the Suez Canal Authority, it became physically impossible to complete or perform his obligations under the sales contract, nor could he transship the cargo because it needed to be brought into berth, etc. So again, very fact specific, but those are some of the potential defenses that cargo interests could take against their contractual counterparts under the sales contract. Whether it will succeed or whether it's a runner will again be very fact specific, depending on the terms of the contract and the fact situation prevalent in at the Great Bitter Lakes where the vessel currently is. So all in all, I think that is a very brief overview and summary of the likely problems that cargo interests are going to encounter. It's not a happy situation for them. Maybe this incident will actually prompt reforms in the way marine insurance cover is written, perhaps a rewriting of the contracts of carriage whereby the risk of such an incident is more evenly allocated onto the owner, all of which remains to be seen, and that's I'm sure that's something all of us will be able to discuss during the question answer session. Thank you very much for listening. Thank you.
I'll take the next.
Thank you. May I have Advocate Karnan Thirupathy?
Yeah, thank you. Thanks very much for the invitation to speak at today's event. And it's also, I've learned a lot from the earlier speakers as well, all very eloquent and knowledgeable. Today, I think what I will be going on into touching on briefly actually is the effect of the Ever Given, not so much on the vessel or the shipping aspects of the cargo owners on the vessel, but actually on the wider effect on trade. And what I will be touching on briefly also is just some thoughts, I think, and perhaps some things for further discussion on how traders should perhaps relook the way they're doing business and what sort of things they should take into account moving forward. So perhaps going into the slides, could I have the first slide, please? I think that's the last one. Right, thank you. The next one. Yes. So Captain Menezes, at the start of this session, he went through the how important the Suez Canal is to trade. So I think that's not something I need to repeat here. I think what I've set out here is really the some examples of the effect of the delays on shipping and trade caused by the Ever Given. Not so much again on the vessel or on cargo owners or owners of cargo on board the vessel, but of other players in the supply chain that have been affected. So examples of things that have happened, of course, have been delays. That's the main problem everyone suffered down the line or up the line, depending on how you're looking at it. We have sellers, manufacturers, factories who have delayed output. So if you are a manufacturer or factory and you're waiting for your raw materials or components to come in to you and that's been delayed, there's a knock-on effect because you can't manufacture and supply your own customers. So that happened on that end. And on the other end, of course, you've got consumers, retailers, buyers who've also had similar issues with delays, right, on their end where they can't receive the goods that they want to use when they need it. The traders, of course, stuck in between, buying and selling the goods that are all delayed. So I think two things to bear in mind about this is that quite apart from just owners of cargo on board waiting vessels, you actually have a knock-on effect down the whole supply chain potentially, right, where you've got stoppage in the Suez Canal, and then as a result, cargo and all these vessels cannot reach their customers in time, and then therefore those customers who need those goods to supply their own customers, can't supply in time, and then there's delays all around. The other thing to bear in mind is also because of the way trade is done, there's lots of companies or businesses out there that use the just-in-time inventory system, which cuts down costs most of the time because your storage costs are cut. You don't have to warehouse things for extended periods. And also you're a bit more flexible, right? You don't actually have to commit to paying for goods that you are not currently using. So just-in-time inventory systems have those sorts of benefits. But when you come to a case like this, where there's a stoppage and your supply is cut and you're completely reliant on that, then what happens is effectively your business or your production shuts down, right? Then you're left scrambling, and it can be catastrophic for businesses that rely wholly on this sort of arrangement. So yeah, so as a result of delays, the consequences are also potentially and often actually contract cancellations and breaches. Not so much about the shipping contracts, where or charter parties where that there's no undertaking by the owners to deliver the vessel by a particular date. The cargo by a particular date. But on the sale contracts, time can be of the essence, and a delay by you would be considered a breach, and then it leads to cancellations and claims for damages and so forth. And of course, the other consequence of it was of the Ever Given would have been increased costs of shipping and of commodities as well, because there'll be a shortage of supply. Because what would have happened is, as a result of the stoppage, there's a shortage of supply. Parties looking to buy the products would have to find alternative buyers closer to home, right? And that would probably have been an increased cost. That's one example of why costs would have gone up. So moving on to the next slide, please. So when such a disruption happens, a trader or a factory or manufacturer, buyer, they're dealt with, they have to deal with some difficult decisions. There's the practical decisions, and then there's the more legal related kind of decisions. So practical decisions that have to be made when there's when this sort of disruption happens. you'd be looking at, the buyers would be looking, or sellers as well, will be looking at alternative supplies closer to home, right? Where they can get the goods that they need within the time they need it. But of course, as explained, the cost would go up, right? It would be it would be more expensive. And then of course, there's issues at the time. It was in the news almost every day, decisions that had to be made by charterers as to whether to reroute or give new instructions or wait for the disruption to clear. At the same time, you'd be looking to try to negotiate terms of your contracts where you get, try to get time extensions from your counterparts, or if not, you'd be left with choices. For example, if you're a manufacturer or a supplier and you've got a limited number of goods to sell, right, and you need the supplies coming in to you to manufacture more goods to meet more of your customers' demands, you'd actually be left with the option of, do you perform some of your contracts and leave the others to be breached, right? Because you just don't have enough goods to supply everyone, or how you've got to allocate your own resources to your existing businesses. So that's the practical issues that had to be sorted out right after the disruption, or shortly after. And the next sort of risks were the more legal aspects of the issues that arose at the time. So you'd be looking to identify whether your losses are insured, or whether they just lie where they fall and you've got to deal with the costs. You had to look at your contracts, right? Sale contracts, whether you're covered, there's exclusions, there's force majeure clauses, and so forth. And then also you'd be looking at whether your contracts as a trader, for example, whether your risks are aligned, right? Are the terms you're selling on the same as the terms you're buying on? So then you'd be looking to see whether you could pass on claims up and down the line. So whatever you receive, you passed on down to your own supplier. I think the difficulty would have happened, that has happened actually in this case, often, is that the contracts are not just simply back-to-back sale contracts. There's a multitude of contracts involved. You've got the charter parties, you've got the BLs and all that on the shipping side. And then at the same time, you've got sales contracts where you're buying from your supplier of your raw materials. And then you've got your own sale contracts up the line with your customer who wants to buy manufactured goods. So it's not easy to pass on risks and claims back to back in those sorts of circumstances. Okay, next slide, please. So moving on now to what sort of lessons I suppose we've learned from this event. I think one of the things to remember is that the Ever Given really isn't a one-off type event. By that, I mean, disruptions to supply chain can happen anytime, right? And anywhere. It doesn't have to be the Suez Canal, although that's of course a very, it's a very good example of how these sorts of things can happen. I think, for example, another example would be in the news just recently, I think a couple of days ago, there's been news of Yantian container terminal in China, having disruptions there due to COVID. And I think some of the shipping companies have been saying that that sort of a disruption at that port, right, transshipment ports, is worse than what's happened in the Ever Given. Right. So yeah, and then I guess the cause of disruptions can be also due to a multitude of things. That could be, wars, blockades, casualties. And then I guess we all know now from COVID that COVID viruses and all that can be a source of disruption as well. So I think the important things are that to note is that you as a trader, you'd be looking at how you manage your risk, right, when something like this happens. So again, there's two different aspects to it. There's managing the risk in practical terms, and then there's managing the risk through what you can through I guess the law and getting your contracts lined up properly. So in terms of managing risks, the first aspect of it for a trader would be to see how you can allocate your risk by contract if these sorts of things happen. So one of the things to look at would be the force majeure clauses in your contracts, and to see whether they are worded widely enough to cover the sorts of disruptions you anticipate could happen in your business. So just generally speaking, force majeure clauses tend to apply only when you are, you're prevented from performing your contract, right? Or there's a significant delay depending on how your contract's worded. So one of the issues is that force majeure clauses tend not to apply when you're not completely prohibited from performing this contract, but it's just become more expensive for you to perform the contract, right? So in the case, the difficulty with force majeure clauses in applying to this sort of a scenario is that you'd probably you'd have a situation where, a factory, for instance, is disrupted in a sense or delayed because he can't get his raw materials or components because vessels are stuck in the Suez Canal, but he can actually perform the contract in a more expensive way by buying the same components from a nearer location that's not affected by the disruption. So in that sense, the protection that can be offered to someone through a force majeure clause is somewhat limited. So the other thing that's possible, right, is to, again, as I touched on briefly earlier, is to try to line up your contracts back to back as far as you can. So by that, what you'd be trying to do is to say, like, if you've committed to do something for your own customer by a particular date or time on those sorts of similar undertakings and promises from the person who is supplying you. Again, that can be quite difficult to arrange, again, because it's not a case, always a case, for example, where, say, you're selling oil or palm oil or something, and your supplier is supplying you the product, you're supplying it on to the next guy. In many instances here, what's coming to you is a component or a raw material that you need to manufacture something while getting components from other people, and then you are selling that on to some wholesaler, and that guy is selling it to retailers. So the contracts may be a bit hard to line up that way. And then, of course, you've got contracts not being back-to-back in the sense that you've got sale contracts that are not identical with chartering contracts, but then you would want to try to see how far you can get the risk in the two contracts lined up. And then, of course, as discussed, we've got the force majeure clauses. You want to have similar force majeure clauses in your contracts up and down the chain. But again, the issue that arises is that what may be a force majeure event in your downstream contract may not be a force majeure event in your upstream contract. By this, I mean that if your supplier is disrupted completely from performing the contract because of a disruption in the Suez Canal, he may be able to rely on the force majeure clause, but you, as a manufacturer, may have other options and you're not completely reliant on that particular supplier, right? So the expectation would be you can go out to the market and get an alternative product at increased cost. So therefore, you are supposed to do that. So in those sorts of scenarios, back-to-back force majeure clauses may not help so much. One thing that you can, however, line up I guess quite one of the easier things to line up, I would say, is your dispute resolution and choice of law clauses in your contracts. So at the very least, if your upstream and downstream contracts have the same choice of law clause, or they refer to arbitration or court in the same jurisdiction, then that maybe offers you some degree of comfort a little bit, because at least you know the same system of law is applying to your upstream and downstream contracts. Okay, next slide, please. Sorry, just going back a bit to the earlier slide, just touching on that very, very briefly. The other way of managing this risk is insurance, right? But and that's been addressed by the earlier speakers a little bit as well. As observed by the earlier speakers, also the main problem is in covering your risk by insurance is that you've got generally the cargo clauses exclude liability cover for delays. So in your institute cargo clauses, which most widely used cargo policy terms, the exclusion says, in no case shall the insurance cover loss, damage, or expense caused by delay, even though the delay may be caused by a risk insured against. So it's very clear that delays are excluded from cover under marine cargo policies. Again, if there is a real need, there is probably a way of getting additional cover, but it's not common as far as I know. But insurance, you can discuss it further with brokers and so forth. But apart from just the marine cargo policies, there's also other policies that may apply for traders or factories, right? For example, you could potentially get cover for delays in or for stock shortfalls, right? Where you've got your inventories run short because of certain events, and perhaps you could get cover for that. But again, everything with insurance is you've got cover, but then you've also got to pay for it, right? So you will have to weigh the pros and cons and so forth before you actually think in order to consider whether insurance is a viable option. Okay, just the next slide, please. Okay, so those were the legal and insurance aspects of thinking about dealing with these sorts of issues when they arise in future. The other aspect of things, which I think is equally important, if not more, is the actual practical aspects of your supply chain risk management and contingency planning. So while the clauses and all that, force majeure clauses and so forth, all do help, and getting insurance does help if you can get it. Those are things, that arise once, problems have already developed. I think this aspect of things is in trying to understand what your processes are going to be in the event something like this happens. So again, I say here it's not a one-size-fits-all situation, because some different solutions may work for different traders, different factories. It depends on, for example, on how dependent your business is on a particular supply or on particular goods going through certain areas and all that. If your commodity or whatever you're buying is not so specific, and there are options, then you'd actually be looking at other things, other options, like getting sources of goods from other places. So examples of things you'd be looking at, depending on your business, would be a diversification of source of goods. So you'd be buying from different locations, so the risk is spread out, right? So you're not just reliant on one transport route. And that ties in with the next point, which is a diversification of transport routes, which is, of course, if you've got goods coming in from different locations, then any one shutdown of one trade route means you still got other avenues of getting your stocks available to you. Reassessing your required stock level. So earlier on, I spoke about just-in-time kind of inventory systems. After this, I think traders who are affected will be looking at reassessing their business practices and determining, do they actually want buffers in stock and supply so that they can perform what they actually their contracts when things like this happen. And then, of course, you've got to have traders establishing contingency plans. So just dealing with things in it, having some foresight and forward planning, and understanding what their processes are going to be when there is a disruption to the supply chain. So, for example, the things that's listed here are, you'd be looking at notifying your counterparts, trying to negotiate postponements, activating your alternative suppliers, because you might have one route which is your best route, and you want to order most of your goods from them, but you should already have identified in advance potential alternatives when something like this happens. And then you'd be looking at reallocating stocks and resources to contracts. So again, like is something I touched on a little bit earlier, where you would already be, as a supplier, say like you've got 20 customers to service, but you've only got limited stock so you can only do half of them. Which half of them are you going to deal with first? And are you going to postpone the rest? Or are you going to be able to negotiate terms where you can cut your supply by 50% to all of them? Okay, next slide, please. Yeah, so this is just basically where I mean, I think the takeaways from what I've said. I think the point is really disruptions will happen in any case, and it's best to be prepared for it. I think while it's all quite scary and we're talking about all the things that can go wrong, the reality is, like I said, it's not a one size fits all kind of arrangement. You might have traders who go, well, this for my business really is going to be 1 in a million or something, or just like the risk of it happening is like 2% and it's okay. So I don't really have to do anything differently. If something like this happens, I'll just, bear the consequences. But then the rest of the time I'm making money and all right, and everything's okay. Because you'd be thinking, or if you're that sort of a trader, you're thinking, if I really wanted to plan for an event like this that's going to be so rare and have not that great a big impact on my business, should I really be paying all the additional insurance premiums just to wait for the day when this happens? Should I think about really incurring all these costs about diversifying my supply chain and all that, even though, just in case this happens? So like I said, some businesses will need to really look into it and plan properly and take into account all their options. But some will go, yeah, it's a risk, I'm aware of it, but I can live with it. So I think that the thing to really remember is, even if you're one of those traders who will go, this is fine, I think, this is not going to affect me much going forward. I'm not going to spend more money on preparing for it to happen. At least take some time to think it through and think what your supply chain is, what your business is, and how these sorts of disruptions will affect you. So yeah, thank you.
Thank you, speakers, for the invaluable insights. I'm sure many of us have a lot to ask of you during the Q&A. But before that, we have a very distinguished chief guest, Mr. Kevin Shakesheff, President of the Institute of Chartered Shipbrokers. He has great knowledge of the Institute and extensive business experience. He has been a member since 1974, Institute Chairman 2007-2009, has been active within the Northeast of England and South Wales and West branches for many years, as well as being on the Federation Council. Presently Chairman and former Managing Director of Casper Shipping, a leading UK port agency, logistics and marine services business. He is also co-founder and former Chairman of the High Tide Foundation and Vice Chairman of the Mission to Siemens. He has an unwavering passion for education, supporting youth, people, and for the Institute. I now request the President of the ICS to address us.
Kevin, you can unmute yourself and speak, please.
Okay, there we are. All good. Well, good afternoon, everyone. I can't disguise my delight at being here this evening. Well done to all the organizers, wonderful speakers, and a magnificent turnout. This is a fantastic event. My congratulations on this wonderful initiative. Nearly 700 guests, wow. For many years, I've been preaching the need for our institute to be relevant to the outside world on topical matters such as the Ever Given. Your presentations demonstrates the professionalism of our organization. This evening is a triumph, is a tribute and triumph to India's professional membership. Well done, everyone. Well, what have we learned? Well, firstly, Captain Menezes set out the scene with a wonderful insight into the history and the working of the canal. The ship movements, the controls, the trade volumes, and the magnitude of it all, and the importance to the trading world of the Suez. I was astounded when the fact came up that 12% of the global trade passes through the Suez. We learned from him of the complexity of involving all the parties, the legal nightmares from that. He explained the enormity of the traffic passing through the canal. And at the end, as always, the seafarer who eventually becomes the victim. And on top of that, I couldn't believe how many different legal systems were involved. I thought Ivor Goveas' brilliant discussion where he introduced us to the fact there were 400 vessels delayed, owners declaring general average, the claim from the SCA, which is now US dollars 550 million, while the vessel is still arrested, and owners are making a counterclaim for US dollars 100 million. And then owners are commencing proceedings in London for a limitation clause to make that 114 million, sorry. And a subsequent claims may be limited to that, subsequent claimants may be limited to that amount. I also found out that the cargo interests may be able to claim that the general average does not apply. There are a variety of insurance organizations involved in all this to deal with all these claims. The financial disputes, whether the grounding of the vessel meant that the vessel was off hire, and that continues while the vessel is still arrested. I find that irresistible listening. The complexity continues whilst details of the governing charter party haven't been disclosed, and that combined with the different types of bills of lading by different carriers. It always comes down in my historical recollections. History tells me it's always down to the charter party and bills of lading, and I guess in this case that's where it will all finish. Zaire pointed out the essential knowledge needed to identify a maritime claim. He looked at the issues through the cargo interest point of view. He clearly defined the main headings: contractual counterpart, general average, does it apply? Salvage, the cargo interest may have to contribute. Force majeure and frustration. Financial losses for physical damage only. For those students studying our ICS exams, our syllabus enables you to identify and understand these major components to a claim. In my long career in shipping, the ICS exams provided me with a wonderful platform to face many of the issues thrown up this evening about the Ever Given. Advocate Cannon eloquently discussed the implications of the blockage on trade. He talked about managing risk, recommending changing routes for ships and suppliers, and reviewing purchasers programs. Carmen explained how cargo policies do not cover delays. What a minefield all this is. Just in conclusion, what we can see is the complexity of a very difficult situation. Claims, counterclaims, charter parties, bills of lading, and how they are all interpreted. Meanwhile, Ever Given remains arrested while the legal wrangles continue. We'll have to watch this space. For those involved who are drawing up charter parties and bills of lading, there are so many lessons to be learned from this incredible incident. And from experience, I remind you, always check and double check before signing off a charter party or a bill of lading. Read the small print thoroughly. So just in finishing on a personal note, my sincere thanks to Captain Menezes, Ravi and Arati and their team for a truly memorable evening, which will not only benefit all here tonight, but also those who are going to see it recorded later. In fact, my local branch in the Northeast are going to have all their students and members view it when it comes up and be part of their training going forward. The use of technology is at the forefront of our deliberations in London. And today's webinar, combined with online learning, will form a major part of our future ICF format. Ladies and gentlemen, it has been an absolute honor to be invited and participate tonight. There's only one regret I have. I wish I could have been here in person. Again, thank you very much. A most enjoyable evening. And thank you to all the speakers.
Thank you, sir, for the succinct sum up of the issues related to the incident. We will now have a 5-minute Q&A as we are short on time. Captain Joseph Alapat, coordinating the Q&A, is Deputy Conservator of Cochin Port. He has 25 years of pilotage experience with 12 years as Harbour Master. His expertise in pilotage includes submarines and rig moves. He has piloted all Cunard ships from the erstwhile QE2 to the latest QE, and all aircraft carriers of India from INS Virat to the under construction INS Vikrant. Over to you, sir.
Right. Thank you very much, Aarti. I hope you can hear me.
Yes, we can.
Thank you. Like you said, we've now had to cut down the question answer session for down to 5 minutes. So I'll have to be very general. I think most of the questions have been answered by the speakers who covered the topic in a very, very detailed and in a wholly completed manner, so that most questions got answered. So we'll limit it. I would just first like to generalize and answer some questions. There were quite a few questions about the actual incident itself, and I would just like to put it that we were not discussing any accident or anything, what the causes were. Because that is a matter of, like we said, investigations and litigations also, I'm sure. And the answer to that will come in the years to come. So it's this is not the purpose for us to discuss that. Like we all know, pilotage waters are extremely challenging because we're trying to move a very big ship through a very small place. In this case, the Suez Canal, and there are always instances where the risks overcome you and there could be an accident. And what we must remember is that we're just discussing the one accident. The number of transit that go on throughout the years without accidents don't get discussed. So we must remember that. So whatever the causes for the accident were, they will be investigated. I'm sure the results will come out and corrective actions as required will be taken, because one thing if it is very clear is nobody wants an accident of this dimension again. So with that, answering all those questions about the pilotage incident of this, I would just raise maybe one or two questions, and I request the replies be kept very brief, given that we have only 5 minutes. So I think the first one, I think Captain Ivo would be to you. I mean, it is a question regarding saying that this is a case of a grounding in confined waters under pilotage, and salvage claims, etc., have come into this. So what the question is that if salvage is applied in this case in any form or terms, there were no. Would it be the same for future cases of grounding? Could salvage claims also come in future cases of grounding in incidents of pilotage and confined waters? Captain Ivo?
Yes, thank you, Joseph. I'm sorry, there seems to be some background noise, but I'll try and speak over it. Well, the thing, it is not unknown that the moment a tug or a vessel puts a rope onto a line onto another vessel to this thing offer assistance, the first thing that comes to their mind is that we are now offering some help. And if it is successful, then we should be able to claim for assistance. So it is very important, I think, depending on the circumstances, as to what exactly the master actually agrees to with the vessels offering assistance. So it's not unusual to see disputes arising out of whether a case is a salvage operation or not. but everybody who offers assistance does try to claim salvage. So unless you actually enter into a specific agreement on some of the BIMCO forms or under the laws of or the Lloyd's Open form, then it is possible that whether it is salvage or no can be disputed. For instance, some areas actually say that if assistance is offered to a vessel in distress within the inland waters of that area, then salvage cannot be claimed. And one of those distinct countries is England, just for information. I've got to keep it brief, as you know, because we don't have much time, but I hope that assists. Thank you.
Right. Thank you very much, Ivan. And I think another question to John, who was the first speaker, Captain John. A question from DIG Venkatesh, if I'm mistaken, if I'm not mistaken. And essentially what was being asked is that there is a trade worth about 200 million with North America, South America from India especially, and this has had a very severe impact on that trade, as it is from everything from the east going to the west. So what would be the best strategy to be adopted in such cases, in case of future grounding? That was the question, John. John, can you hear me?
I mean, like, you'll have to look at it that this is a one-off incident and a temporary blockage. I mean, it is not a thing that is is not offset the entire system per se. I mean, in the sense, like, the Suez Canal has had such a distinction that if you had to take the incidents of in 2018 of the Panamax Alexander, I mean, there were 5 casualties, one after the other, I mean, in the sense, and that was sorted out in such a short period of time. Even here, 6 days, I mean, things were back to normal. I mean, they give credit to the Suez Canal Authority that the backlog of 400 and odd ships were cleared in a matter of 5 days with practically more than 80 crossings per day. So, I mean, like I think even Kanan had mentioned, we have to look in terms of alternatives. It has been a wake-up call, and we cannot take things for granted. And alternatives will be worked for by the manufacturers as well as the raw importers. So I mean, like, I wouldn't be too perturbed on this because it was a temporary blockage, not a permanent blockage. I mean, anywhere, any particular shipping lane or international waters. Over.
Right. Thanks, John. And I think we have time for one last question. I've been keeping an eye on the chat box, and I didn't find any questions there. So the question that we received by email, we will definitely try to get back to you in due course, since we don't have enough time to answer all those questions. So to the last question that I could probably address it to Zarir, it's a question on general average, since general average has been declared for this vessel, this incident. The question was whether do you see any introduction of new clauses in the charter party by cargo interests to protect themselves in such cases? That's the question, Zarir.
That's a good, difficult question. I think general average, generally speaking, will be governed by traditional rules. But I think the question is, would there be anything in the terms and conditions of the contract of carriage? Charter party don't really make a difference unless it's incorporated. I think it'll depend on how the wording and the bills of lading are taken care of. It is possible for the charter party to be modified, but again, these are standard term contracts, right? And much depends on the bargaining position of the owners and the charterers. The honest truth is I don't know, because it's really, I'm sure contractually you can allocate the risk away from cargo interests, but whether that's commercially possible, I can't comment on. The marine insurance industry would be better placed to comment on that.
Thank you, Aarti.
Thank you, sir. Thank you, Captain Joseph, for moderating the Q&A. Thank you is such a beautiful word. And who better than Captain Tom Joseph, Chairman, Nautical Institute, India Southwest Branch, to do the honors. I invite Captain Tom Joseph to deliver the vote of thanks.
Thank you, Adi. Honored Chief Guest, Mr. Kevin Shakesheff, FICS President, ICS London, Mr. Ravi Tittee, FICS Chairman, ICS East India, respected and well-learned panelists, Captain John Lloyd, FNI CEO of NI London, distinguished guests, colleagues, and friends. Nautical Institute as a professional body like ICS has always stood in the forefront when it comes to sharing the professional experiences with the marine world, solely aiming at the professional development of its members. Whereas Nautical Institute is a 50-year-old celebrating its Golden Jubilee this year, ICS is a 110-year-old professional body. It could be premature to announce it today, but we at NA India Southwest are planning to host one of the 12 international meetings to celebrate the Golden Jubilee of NI at Cochin towards the end of this year. NI has over 7,000 members spread in 110 countries, and ICS has around 5,000 members in 25 locations worldwide. Needless to mention that both the bodies are headquartered in London. NA India Southwest branch was formed only in 2015, and today we have about 115 listed NA members. As we know, there could have been no better topic for discussion than today's topic, Suez Canal blockage, which happened just less than 3 months ago. It is such a contemporary topic which caught the attention of general public who never really bothered about shipping and the sea trade. Presumably about 422 ships were stranded on both ends of Suez and Mediterranean Sea, creating a chain reaction to world trade across the globe. We at the Nautical Institute India Southwest Branch is extremely thankful to the organizers for giving us an opportunity to be co-host for this webinar. It is heartening that the two international professional bodies are jointly hosting this event. Though the planning was done with a very short notice, I would like to thank all those who worked behind the curtain to make the event a grand success. The very fact that is evident from the large number of attendees online today is shows the success of this event. Let me also announce that NA India Southwest, jointly with ICS East India, will have a follow-up meeting on the same topic sometime in August. We expect and look forward to each one of you to be attending that too. On behalf of ICS East India and NA India Southwest, I profusely thank Mr. Kevin Shakesheff, FICS President of Institute of Chartered Shipbrokers, for consenting to be our chief guest today and for speaking to us and moderating the subject. The 4 panelists today have enriched our knowledge as far as the Suez Canal episode is concerned. I thank each of them, Captain John Menezes, Captain Ivar Goveas, Advocate Zarir Bharucha, and Advocate Karnan Thirupathy for enlightening us on 4 different aspects related to the event. I would also thank Mr. Ravi Tittee, FICS President of ICS East India, for virtually welcoming all, and Captain Joseph Alapat, FNI Vice President, NA India Southwest, who also happens to be the Deputy Conservator of Cochin Port, for taking on the question and answer session. It would not be out of place for me to specially thank Ms. Aarti Narayanan, MICS, for taking proactive interest in angling this webinar and conducting it exemplarily well. I thank each and every honored members of Institute of Chartered Shipbrokers and fellow members of the Nautical Institute for gracing this event virtually. A big thank you to media who is covering this, specifically Captain of Maddox Bulletin and Saga Sandesh. We have many dignitaries watching this event, particularly Captain John Lloyd, I could see, and many other distinguished guests. Let me thank each one of you, particularly those who have graced this event now online, as well as those who may be watching it offline. Thank you for watching, and thank you all. Have a good day. Good evening.
Thank you, Captain. All good things come to an end, and we hope to meet all of you soon. Until then, thank you for joining us this afternoon. Thank you very much.